Hi, my name is Damien Grant. I'm the director of Tempest. We are a debt buying company. This is my third video in respect to the Decmil liquidation. Most creditors would have received this information pack from the Australian-based liquidator, Mr. McVeigh. There's a couple of things that I need to address. In this document, Mr. McVeigh, for the second or third time, refers to the fact that Tempest is a debt buying company and we have acquired a debt in the liquidation of Decmil. I don't understand why Mr. McVeigh keeps mentioning this or the price that we pay for it. It is irrelevant. Tempest is a debt buying company. We buy debts, including debts for companies in liquidation, if we believe there's a commercial opportunity, and we believe that here. Just to be really clear, if Tempest is able to get 10 or 15 cents on the dollar back on our debts, all other unsecured creditors will get exactly the same pay back as well, and I'm interested in securing that. If we are successful in replacing Mr. McVeigh, Tempest may well be in the market to buy more debts in this liquidation. If you're a creditor in Decmil, that should give you some confidence that replacing this liquidator is the right thing to do. Mr. McVeigh also seems to be implying that Tempest and the Department of Corrections is somehow acting in unison. This is utterly untrue. We are not. The only formal correspondence or interaction I've had with Corrections is to make sure that the liquidator that I was proposing was going to be acceptable to the Department of Corrections. Any other allegation that Mr. McVeigh is attempting to convey in this is utterly untrue, and it is a discredit to him that he continues to peddle this nonsense. There is another issue. In this document, Mr. McVeigh is calling a creditors meeting, and he's calling the creditors meeting for 4 p.m. on the 24th of June. This is to be done by postal vote. In this document, Mr. McVeigh has advised the creditors that proxies are allowed to be in by 4 p.m. on the 24th of June, the date of the creditors meeting. Mr. McVeigh is wrong. Under New Zealand law, proxies must be in 2 working days beforehand. To be safe, that means proxies must be in by this Friday. A proxy that arrives after that date cannot, absolutely cannot, by New Zealand law, be counted by Mr. McVeigh. It does not matter that he made a mistake in this documentation. There is no discretion. We have written to Mr. McVeigh requesting him that he inform all of the creditors of this particularly significant error. It's a problem. The third thing I want to point out is that, once again, Mr. McVeigh has rushed off to court. This is the second time Mr. McVeigh has charged off to court. The first time is he sought to prevent the Department of Corrections from claiming a bond. I don't understand how Mr. McVeigh thought he was going to win this. A bond in New Zealand is able to be called if the debtor company goes into liquidation, and that is what happened here. Decmil went into liquidation. The Department of Corrections, like any creditor in that situation, was able to collect the bond. This was a foolhardy waste of creditors' money, and in addition to the legal costs incurred, the creditors are also going to be lumped with a cost award that will come out of the funds available. The other thing is, if you read this particular document, Mr. McVeigh has actually provided us with the decision from the court regarding this creditors meeting, and it will become apparent if you read it that Mr. McVeigh did not need to go to court to do this. He is holding a creditors meeting by postal vote. That is allowed under New Zealand law. He did not need to go to court to do it. He did need to go to court to have more time to hold a creditors meeting, but frankly, he could have held the postal vote within the time frames originally requested by Tempest when we called the creditors meeting. Mr. McVeigh is also indicating that he wants to go to court to clarify whether the money held by the company, there's $3 million in cash in this company, whether that money is retention creditors' money or not. On the surface of it, it seems pretty obvious to me that that $3 million is retention creditors. But nonetheless, in New Zealand, there is an expectation on the liquidator to make those sorts of decisions. People can challenge him later if he gets it wrong, but unless there is some incredibly complex area of law or fact here, and frankly I don't understand why there would be, Mr. McVeigh shouldn't be rushing off to court to have this done. The problem is that Mr. McVeigh consistently does not seem to understand New Zealand's insolvency law, and why would he? He's based in Perth, and that's part of the reason why we believe that he should not be involved in this liquidation. Most of you, or a large number of you, have already provided us with a proxy. Those of you who have, we've sent communication out to you today, thanking you. Those of you who haven't, we really need that proxy by this Friday. So if you haven't completed it, please do so. There is information attached below. If you wish to vote by postal vote, that postal vote can be completed by the 24th, which means that you can watch the information being presented by Mr. McVeigh on Monday and then vote in a couple of days afterwards. Mr. McVeigh is correct in that instant postal votes can be done up until 4 o'clock on the 24th. That's all for me. Thank you so much. If you'd like to be in contact, either my details or Zelda Nichols from our office is attached below. Thank you.